Lawyers. What is the dumbest thing your client has done to ruin a case? Not an attorney, but I was on the jury for a 3-defendant trial. We sat through weeks of testimony, and from the sheer amount of direct evidence the state had, it was extraordinarily obvious very early on that defendant number 1 had committed the crime. Defendant 2, D1's brother, and defendant 3, D1's girlfriend, were much less obvious, and we were being asked by the state to consider circumstantial evidence that left most of us feeling like we had to make some leaps to draw the conclusion they wanted us to. That is, until defendant 3 decided to take the stand. Defendant 3's attorney did a very good job of painting her as the victim of cruelty. Her attorney had us feeling sorry for this poor, unintelligent woman. From the attorney's narrative, D3 was basically D1's slave. He controlled what she wore, what she did, and even who she talked to. He even made her get a tattoo saying D1's name's property. We saw text about D1 harming D3's pet because D3 made him mad about something small. We saw texts from D3 to D1 cheering him on after he had sent her pictures of a knife, the weapon, but D3's attorney had us questioning if those words were just her playing the role of supportive partner so D1 didn't come after her next. We were starting to believe she was terrified for her own safety and that this is why she did not report her boyfriend. I mean, clearly this man was a maniac, and it seemed reasonable that she just didn't know how to escape him. Then other defendants' attorneys and the DA tore her apart on cross. They made her look argumentative, tripped her up in multiple lies, and by the time they were done, based on her own testimony, it was pretty clear that she did in fact know the victim and had been the one to plan the entire crime. Shoot, we even started to feel like she probably manipulated D1 more than he manipulated her. The other defendants did not take a stand. When we went to deliberations, we all discussed how bad of an idea it was for her to testify. We had decided defendant 1 was guilty in all counts within the first 5 minutes. Defendant 3 was almost as quick. We decided that while she did not physically commit the crime, she had conspired and was just as culpable, whatever formal charge that was. Defendant 2 took the longest. We all felt pretty strongly that he was somehow involved, but that the DA had not met their burden of proof beyond a reasonable doubt. So we had to return a not guilty verdict on all counts. For clarification, D1 and D3 were both found guilty on multiple counts. D2 was found not guilty. Might have not been the ideal outcome, but it was the best outcome there could be. Story 2. Legal videographer here. Videotaped a deposition for a man claiming work injuries so severe he could not raise his right hand above his shoulder, and his shoulder was in pain whenever he even tried to raise it above the shoulder. Sued his employer claiming it was a work injury. Then came his very first deposition. Does anybody know the first thing the court reporter asks of the person testifying? The reporter swears them in by saying, "Would you please raise your right hand and repeat after me?" Then administers the oath to tell the truth. Man who claimed not to be able to raise his hand above his shoulder raised his hand way above his shoulder. That hand and arm went up like a rocket. The guy did not even realize what he had done and kept his arm through the whole oath. Neither plaintiff or defense counsel caught it. The court reporter and I just looked at each other and let the depo play out. I was hired by defense counsel and showed him the first 20 seconds of the video and took home a nice bonus because of it. Case was dropped shortly after that depo. Story 3. I'm a lawyer. I could write a book about this. Most dumb things happen when I'm out of office or on trial and can't correct their behavior. Most common, lying about easily verifiable small things in the stand. Ruins credibility completely. You know you didn't pick your child up every single time from daycare because the daycare has a log and your mom signed the kid out 50% of the time. You know you filed multiple restraining orders on your spouse because it is an electronic public record. Second most common, changing their story in the stand. I prepared for facts to be the way you told me. I can't prepare for something I don't know about. Third most common, completely ignoring advice. I told you that you couldn't take that $150,000 out of the bank account without repercussions. Incoming contempt. Order to sell the marital home. Home is actively for sale with a realtor. Client puts a padlock on the house so no one can access it or sell it. Here comes contempt. After 5 years, I finally got a client custody of the kids. When the client went to pick up the kids, the client brought a known violent felon, a loaded weapon, and got physical with the guardian. Emergency petition filed, children removed from her care. Had them for less than a week. Had the audacity to call me a bad attorney in front of the judge because the kids were removed. Judge laughed and informed the client I had won the case for her until her own actions caused this reversal. Allowed me to withdraw on the spot. Story 4. One of the first and only divorce cases I took as a solo was a man who said his wife had run away back to Nepal and abandoned him and their 7-year-old daughter in the States. He said he had no way to get in touch with her or find her and that she was likely with a new lover. So we effect service by publication, file everything at the court, and the case is rolling along uncontested. Until the wife shows up, gets her own lawyer, and shows that her husband knew where she was the whole time. He admits to me via email that he may have been a bit deceptive with me. I told him that if he was willing to be fully truthful with me going forward, we could work with the wife's attorney to come up with an agreement, but that he would need to pay me more because now it's a messy contested divorce and his small retainer for uncontested is depleted. He did not do either of these things. I had zero faith he would not continue to lie. He gave me more reasons to see that he was continuing to lie to me, so after telling him I could not represent him anymore, I filed for withdrawal for representation, a mandatory one based on fraud to the court. Show up to court for the motion hearing and he stands up and says he objects and doesn't want me to withdraw. Said I'm only trying to walk because of the money and then tries to hand over every communication we've had to the court. He printed all of our emails. Wife's lawyer looks at me as the client is trying to hand these over and informs him that they would get to see everything as well. So maybe that's not a great idea. Wife's lawyer was really great. Judge is dumbfounded. I tell him it's a mandatory withdrawal and if I give any additional info, I'm prejudicing my soon-to-be ex-client. Judge briefly tried to explain to the client what that meant and allowed my motion. He shut up and I walked out. A lot of these people really just dig their own graves. Story 5. Not going to badmouth my former clients, even ones who might deserve it, but my opposing counsel's client. Suing a debt collector for freezing my client's bank account without first obtaining a judgment against her. Big no-no here in New York. This guy has been in the industry since before I was born, so I know it was not an accident, and suspected that there was some reason he could not sue and that was why he did it. But I thought there was no way we would be able to prove that we would settle out relatively cheap because there was no way we could prove it was anything more than negligence. This doofus produces the records for the underlying debt. One of them looks very clearly digitally altered, so I subpoena the creditor. Sure enough, he changed the date of default to try to hide that the debt was time-barred, as in that he could not file a lawsuit about it. That certainly would not have been good for him, but he still could have argued that it was not enough to prove intent. However, nothing quite infers intent like trying to do a cover-up. This poor attorney did not check the discovery carefully enough and totally missed it and had to withdraw from the case because he just accidentally suborned perjury. It was great for me and my client. Moral of the story, if you do something bad and get caught, trying to lie and cover it up will often get you in way more trouble. Story 6. I'm not a lawyer, this isn't my story, but the lawyer who handled my business stuff in a legal dispute is a federal judge. Before he became a judge, he was a lawyer for divorces and civil stuff. A wealthy male client filed for divorce. There's a prenup. It's pretty ironclad. It discusses the distribution of wealth, the alimony, if any, is laid out at X amount, increasing yearly based on inflation. There's one major exception, and that is, if you're caught cheating, cheating here is defined by any intimate contact with a person before the divorce is final. You automatically get the worst terms of the prenup. In the woman's case, if she cheats, she gets zero alimony, and a one-time payment of $100,000. In the man's case, if he cheats, he loses the main family home, all cars that are not his daily driver, and 1/4 of his business. A buyout option is available, but doesn't matter to the story. Lawyer gets to court and meets with his client in a conference room, and client is beaming. He shakes the lawyer's hand and says, "Hey, Mike, I want you to meet Jasmine. I met her 2 months ago. She's amazing. We got engaged over the weekend in France." And Mike shook her hand and slumped in the chair and said, "So, we have a major problem. You're cheating on your wife with her, and legally this is a discovery I'm required to hand over to the other side." He's all, "How the hell am I cheating? We're separated." Mike is all, "Cheating is any intimate contact before divorce is final. It's in your prenup that you wrote on your own." The guy flipped his stuff, ended up being so mad he ditched court, which gave him a default judgment, meaning she gets everything she asked for. Plus, because of the cheating, plus not showing up, the judge ordered that the transfer of money happen within 30 days. As part of the initial agreement between both parties, he's not there to contest it, so blame. The guy ended up trying to sneak the company to the new woman via trust, but it's an illegal move. He also tried to hide the money with her by giving her $1.1 million in cash, a bank transfer. But the judge stopped that once he found out and required the woman to repay the money since she was given notice also. He fought for years and ended up losing money, time, energy, his business, house, 6 to 7 cars, and his new wife. Now, because I know his daughter from work, he's a retired angry man living in rural New Mexico. He can't afford to golf more than once a month, and he posts about how women are scum. Sounds like the typical rich guy always getting his way no matter what. He figured there are no consequences that he can't just buy his way out of. Extra points for the irony of getting screwed over by his own prenup. Enjoying the video so far? Don't forget to hit the like button and subscribe to my channel for more awesome content like this one. Story 7. Not a lawyer, but was raised by one. He did criminal defense for 30+ years in Texas before taking a position with the DA. Here's some good ones. Case where I persuaded DA to waive the death penalty. Turns out that the jury acquits on the other charge, but charges him with aggravated robbery and sentenced him to 45 years. Defendant's family was all mobbed up in the Mexican mafia. They all, mother, grandmother, etc., wore Mickey Mouse shirts. Get it? Mexican mafia. DA was plenty pissed about the outcome of that trial. I got the better of him in that one. Defendant's name was an interesting case because halfway through the trial, the defendant's brother takes the stand and confesses to the crime. I didn't see that coming. Turns out that the defendant and the brother cooked this all up before trial without my knowledge, of course. Anyway, nobody but the defendant's mother believed him. The jury convicted and the brother was indicted for aggravated perjury. My personal favorite, client goes on trial for a robbery charge. He shows up for the first day of court, does not show up for the second day of court. Judge says, well, the show must go on. So my dad has to continue with trial, does the very best he can with an empty table behind him. The jury very clearly pitied him. Client was picked up a few days later in Oklahoma. He'd robbed a bank and went to the airport to purchase plane tickets to Hawaii or something. That's where they arrested him. He later told officers that he had planned to steal a boat once he landed. But the absolute worst thing a client did to ruin a case? Chose to represent himself. It was horrible. I won't go into detail, but my dad ended up standing in the back of the courtroom per the judge's order, literally stand by the counsel. Client was absolutely insane, but still, it was bad. Jury gave him life. Appellate court overturned and remained for a new trial. Client wisely opted for representation for the entire trial, got 40 years that time. Story 8. Not a lawyer, but my ex totally messed up his custody case. In a nutshell, the mother took off with the kid and refused to return him in a state where that kind of action would get even supervised visitation taken from her. When she finally sent the child for visitation, the child had visible injuries caused by her boyfriend. The child told his teacher at school, completely unprompted, that the boyfriend had hurt him. My ex's parents hired an attorney for him and they got an ex-parte order to keep the child. At the first hearing after the ex-parte order, both the mother and father were ordered to take substance tests before the next hearing. My ex had a history of substance use, grass. His attorney told him he could get the next hearing pushed back by more than a month so that he could be sure he would test clean, and my ex told him not to worry about it. Then did some snow and failed the test. And didn't show for court and refused to contact his attorney for months until the attorney had himself removed as the attorney on record. The child was actually at the mother's for visitation when the results came back, so she was able to get an ex-parte order to keep him. The reality was, he didn't actually want full responsibility for the child, but refused to admit that to his parents. So he deliberately blew the test and then claimed that since he worked in construction, he must have been exposed to something that caused the failed test. I don't know if his parents really believed that, but I was with him for several years before I found out the whole story. He had previously told me he didn't have money for an attorney to fight, so he just gave her custody. And I left him immediately after finding out the truth. It was bad enough that he just didn't want to be a full-time parent, but to do that in a situation when you know your child is being mistreated? Needless to say, it was one of the things that helped me figure out he was a sociopath. Story 9. I'm a lawyer. I was cross-examining a slip-and-fall plaintiff on the stand-in trial after 2 years of litigation. We were going over some pictures he took when he let slip that the picture of the 2 signs was missing. I grilled him on what he meant until the judge chastised me for trying to conduct discovery during trial, which is supposedly not allowed. He had clearly concealed evidence, though. We took a break for the day, and the next day he came back with a photo in question, which showed that he had walked squarely between 2 wet floor signs to go down the Kroger aisle that he immediately slipped and fell in. He did not recover any money in that one, despite the horrific defense venue. The judge who jumped all over me for exploring obvious evidence tampering was later appointed to the federal bench here in Atlanta. Another one, pro bono VAWA case. Should have been a straightforward petition. Ran a FOIA search on the client before the final submission, just in case. Turns out she had been deported from Guam, and then while her immigration ban was still in place, she entered the mainland U.S. with that status, permanently ineligible for adjustment. When I asked why she had not disclosed this during intake, her response was, "Oh, I thought Guam was its own country and not part of the U.S., so it wouldn't matter." Story 10. Not an attorney, but I had a woman I arrested for a probable cause hearing. The charge was for escape. She'd cut off her GPS anklet and ran, and PC hearings for these sorts of things were very uncommon. Normally only new public defenders used them, outside of a couple of other defense strategies for more serious offenses. Point being, there wasn't a whole lot of reason for having the hearing. She cut the anklet off, we had evidence of that, due to the anklet having been recovered. Lol. Anyway, not only did she want the PC hearing, she demanded to testify. Her public defender, a newish one at the time, strongly recommended against it. He went and got another PD who had a good rapport with this woman. Obviously, she was very familiar with our criminal court, who again recommended that she not testify. Nope, our girl wanted her time in the stand, so the hearing goes forward. Before it started, even the judge strongly recommended the defendant not go through with the hearing. Well, she did. Her testimony was that she'd been taken against her will by her boyfriend and that he made her cut off the anklet, blah blah. was called up as a witness, provided screenshots of the defendant's FB account where she was shown with her boyfriend, smiling happily, enjoying time with him and her daughter, etc. All day and time stamped, of course. Obviously, probable cause was found by the judge that a crime had been committed and the case was sent to the grand jury for indictment. But actually having a judge tell the defendant that testifying was a bad idea was a first for me. That actually happens more often than you realize. Story 11. I started at a new law firm that was in the middle of a long false advertising litigation. Our client, defendant, maintained that their advertising claims were supported by a scientific report written years before that now no one could find. The scientist who'd run the test said he remembered doing them but could not remember the results. The case progresses to trial, and at the close of plaintiff's evidence, my client's CFO bursts into the federal courtroom holding, I kid you not, a copy of the report that he had found in the back of some cabinet he was cleaning out for God knows what reason. Pandemonium. Plaintiff calls for mistrial, judge is hanging his gavel, parties are yelling at each other across the aisle, my boss is objecting into thin air and no one is listening to anyone. The report supported literally nothing in the advertising. Great evidence for the plaintiff's case, confirmed everything they claimed in the complaint. We got dragged for like $10 million in losses. I left the firm shortly after, in part because I was convinced that my boss and the CEO had burned what they thought was every last copy, and I still think the CFO kept one and did this on purpose because of beef with the CEO. Story 12. Fran's dad, Sam, is a well-known, well-connected lawyer in a state with pretty tough drug laws. Her 22-year-old cousin Brian was caught with grass in this state. It was all his. But under the laws of his state, the amount Brian had added a trafficking charge to his charges. This was a serious charge which could result in serious jail time. Sam doesn't want his 22-year-old nephew to go to jail for any time. Sam goes and pulls every string and calls in every favor he can, and when the case goes to trial, Brian pretty much just gets a suspended sentence and walks out of the courtroom. Sam reiterates how lucky Brian is not to have lasting repercussions from this, that Brian needs to make better choices in his life. He should consider this a lesson learned, and most importantly, Sam cannot and will not help Brian again if Brian is caught with substances. Sam made it clear that these types of favors can be used once. If Brian screwed up, Brian was on his own. Sam made this crystal clear, multiple times. Well, guess who was arrested for substance possession about 6 months later? If you guessed Brian, you'd be right. So of course Brian calls Sam begging for help. Sam said, absolutely not. You got my help once, you don't get it a second time. Actions of consequences. Thankfully for Brian, it was a smaller amount, but he still did get sentenced to 9 months, which he served. Honestly speaking, it really did derail his life for many years. Ultimately, however, he met a great woman who really helped get his life back on track, to the extent he could with a criminal. This guy literally had a get-out-of-jail-free card handed to him and still screwed it up. Well, if you like these stories, here's more. YouTube thinks you're gonna love this. Catch you in that video.